To begin our unit on abortion, we're going to look at the 1973 Supreme Court case, Roe versus Wade. Roe versus Wade is the central case for understanding American law concerning abortion. And this is so even though Roe versus Wade was overturned in 2022, Roe versus Wade argued that the Constitution protected a person's right to procure an abortion, that it was constitutionally protected. That claim is at the very center of any attempt to address American law and abortion. And Dobbs versus Jackson, which we'll talk about more in a little bit, which overturned Roe versus Wade in 2022, simply argued that there was no such constitutional right, that you can't find such a right in the Constitution. And so absolutely central even to Dobbs versus Jackson, which was the overturning of Roe versus Wade, is the reasoning of Roe versus Wade. And so we're going to try to understand what that reasoning is, how it works. Now, to understand the court case, we're going to need to first understand a little bit of the background and a little bit of the context. And that's what I'm going to provide here in this video. So, prior to Roe versus Wade, which again is from 1973, the federal government, the United States government, didn't say anything about abortion. It had no laws. It didn't allow it. It didn't disallow it. It said nothing about abortion. And per the 10th Amendment of the U.S. Constitution, the kind of understanding within the United States at the time was that abortion therefore fell to the individual states to regulate. The 10th Amendment, more or less, which I have there on the screen for you, but more or less simply states that anything that isn't explicitly given to the federal government to do falls to the states. The Constitution doesn't explicitly say that the federal government can regulate abortion. And so therefore, the understanding prior to Roe versus Wade was that abortion was a state's issue. And so the federal government, the United States government, didn't regulate abortion prior to Roe versus Wade. Rather, individual states did. And Texas, along with some other states, Texas was not alone, chose to regulate abortion by more or less totally disallowing it. So the Texas law, which had been by the time Roe versus Wade came about, the Texas law had been on its books for nearly 100 years, and it more or less completely prohibited abortion. It prohibited it in every circumstance except when it was necessary to save the life of the mother. Other than that, you weren't allowed to procure an abortion. And like I said, other states had similar such restrictions on their books. And so that was how things were prior to Roe versus Wade. Some states restricted abortion very heavily, such as Texas. Some states didn't. It was up to the states. Well, in 1969, a Texas woman by the name of Norma McCorvey was pregnant and she wanted to procure an abortion. But because of the Texas law, she was unable to. And so she brought suit against the state of Texas. Now, oftentimes when someone would bring a kind of private citizen would bring suit against a state or something like that, they would use a pseudonym. And that's what Norma McCorvey did. She used the pseudonym Jane Roe. And so the Roe in Roe versus Wade comes from Norma McCorvey. That was her name in the suit. The Wade, that was Henry Wade. He was the district attorney for the relevant district or county or wherever in Texas. So when Norma McCorvey challenged the Texas law, Wade was uh, tasked with defending the state of Texas. And so that's where the case, Roe versus Wade, that's where those names come from. Now, if you follow the Supreme Court at all, uh, you will be aware of the fact that it can take a while for cases to make their way to the Supreme Court. And so she brought the suit in 1969, but it didn't find its way to the Supreme Court until 4 years later, 1973. Now, in the meantime, for those who are curious, Norma McCorvey ended up having the baby that she was pregnant with and put the baby up for adoption. Eventually, the case finds its way to the Supreme Court, 1973. And the Supreme Court rules, and we're going to look at this in detail, that the Texas law is unconstitutional. And so Roe versus Wade, this Supreme Court decision, kind of what it's doing most immediately is overturning this Texas law. It is saying that this Texas law, which more or less totally prohibited abortion, is unconstitutional. It violates the U.S. Constitution. Now, that has ramifications not just for Texas. Obviously, it does for Texas. It meant that Texas's law was no longer valid and it couldn't be enforced. But like I was saying earlier, other states had similar such laws. All of those laws were likewise overturned by Roe versus Wade. And so Roe versus Wade enshrined a constitutional right to procure an abortion and therefore overturned all of these abortion bans that were on the books in the various states. Now, what ends up happening is, fast forward however many years, 50 years there or thereabouts. In 2018, the state of Mississippi passed a law which banned abortion, more or less, after 15 weeks. Now, we haven't seen the details of what Roe versus Wade says, but we'll get to it in subsequent videos. A ban on abortion after 15 weeks very clearly violates what Roe versus Wade had said. And so Mississippi put forward this law in 2018 that violated very clearly Roe versus Wade. Well, so what happens at that point? Well, what happens is a Mississippi resident, uh, much like Norma McCorvey had back in 1969, brought suit against the state of Mississippi, challenging the law, trying to argue that it was unconstitutional. Now, again, like with Roe versus Wade, it takes years for these court cases to find their way to the Supreme Court. And eventually, 2022, this Mississippi case finds its way to the Supreme Court. And very clearly, the law violates Roe versus Wade. But what the Supreme Court in 2022 argued was that what was wrong here was not so much the law as Roe versus Wade. And so in 2022, the Supreme Court argued that Roe versus Wade was, in fact, wrong to find a constitutionally protected right to procure an abortion within the Constitution. It's just not there. That's what Dobbs versus Jackson argued. And so what that case ended up doing is not just upholding the Mississippi law, although it did that, it ended up allowing any state to more or less ban abortion. It returned the decision to regulate abortion to the states. It returned this American law, the state of American law surrounding abortion, basically back to the way it was prior to Roe versus Wade. And so again, it didn't say that abortion must not be allowed anywhere. that abortion is totally banned in the United States. It didn't create any kind of federal legislation which said that. Rather, what Dobbs versus Jackson does is it simply says it's up to the states to decide what to do with regard to abortion. It's not a matter for the federal government to be involved in. That's what Dobbs versus Jackson does. And so what we've seen happen in the time since Dobbs versus Jackson is some states have more or less gone on as before under Roe. So, for instance, Illinois. Um, in Illinois, abortion is more or less completely legal and allowed up until fetal viability, which is around 24 weeks. That's basically what Roe had found. And then after 24 weeks, it's still allowed, but certain conditions might need to be met and so on. And so within Illinois, for instance, nothing much changed at all. In other states, for instance, Mississippi, a lot changed. Abortion became greatly restricted. What Dobbs does is returns it to the states, and so the states now decide. Now, what we're going to do to try to understand how this is working, to try to understand the state of American law, is we're going to try to understand Roe versus Wade in a bit more detail.